This Guy's Garage. Like and subscribe.
Beginning with Mr. Brock for 6 minutes.
Thank you, Chair, and thank you, Chief Davis and Chief Montour, as well as Superintendent Lucky for your attendance today. This is an extremely important topic that we are trying to produce a report to the House of Commons to effect change. It's near and dear to my heart, given my previous career. So I'm going to try to split my time as equitably as possible, but I'm going to start my time with you, Chief Davis. We've heard from the Minister of Justice, also known as the Attorney General, Canada's chief lawyer, chief prosecutor, who made, in my opinion, some pretty inflammatory comments. Comments that would only come from an academic. And that's his background, academia. He taught law. He did not practice law in the trenches. We have a couple of prosecutors on this Conservative team right now. I want to separate theory and academic from reality. Some topics, some lines that the minister uses as follows. Our bail system is sound and strong. That there's a law that already tells us that if the accused is a threat to public safety, they should not be released on bail. It's erroneous to attribute recent events, such as the killing of the OPP officer, to Bill 75. That Bill 75 made it harder to receive bail, and that individuals are not supposed to get bail if they fall within the enumerated classes under Section 515, a flight risk, a danger to the community, and where the administration of justice would be brought into disrepute, known as the tertiary grounds. That's theory. Let's talk about reality. What do you say?
Thank you, Mr. Brock. The example I gave, I think, speaks volumes. Greg Porcello was killed December 27th. The individual in the example I gave had committed an offense, was held for bail on January 12th, released, violated his bail when the officers in Brantford dealt with him on February 12th. A lengthy record for violence, firearms, conviction for manslaughter, yet he was out on bail. And so the reality is that it's not working. And let's go beyond the focus is about police officers now because of the deaths, and I get that. But in this situation, this was a person passed out in a cab. So what about that poor cab driver who's out there trying to make a living, and the risk to their safety and to the average citizen's safety in this country?
Hey, quickly. In my previous career, I often heard the phrase that the accused know how to game the bail system. Can you elaborate on that in the context of the application of GLADU?
Quite candidly, people will, through their lawyers, will shop. They'll shop for a justice of the peace that's going to be very lenient with the GLADU considerations, and the minute that they identify as being Indigenous, there's a very high likelihood that they're going to be released with minimal conditions. And so you see this shopping quite regularly.
Over to you, Chief Montour. I don't know if this was attributable to you or to Chief Davis, but GLADU is being exploited. Please expand upon that from the perspective of the accused, but more importantly, from the perspective of the community.
From the perspective of the accused, as Chief Davis said in his opening statement, there's no proof for these offenders to prove that they are Indigenous. They're taken at their word. And there are individuals...
Can you elaborate on that, please?
What
does that mean? They're just taken at their word.
They provide no proof as to if their identity of they are Indigenous. They could have great-grandparents who are Indigenous, and that factors into whether or not they receive bail based on the GLADU factors. And to me, that's... I gotta ask how many generations since the residential school factors in for those people undergoing intergenerational trauma. Some people are using this as a crutch. And to me, it hits home because of the people that we deal with on the territory. We know our community. We know who grew up there. I know practically all of the people my age. If I don't know someone, the younger generation does. And yet we hear of these people explaining to or saying to justices of the peace that they are Indigenous, well, through their lawyers, of course. And to me, like, I scratch my head to say, is there no proof that this has to happen where they provide some sort of background information of their ancestry?
Okay, thank you. Over to you with my time remaining, Superintendent Leckie. I was quite interested in your commentary with respect to the number of breach charges, undertaking, recognizance, breach of probation, failing to appear, key grounds that will allow any justice or judge to to detain an individual. And you cite in one particular city, 50% of those charges are being stayed, withdrawn, or dismissed. What does that say? What kind of communicative piece is that giving to offenders across this country, but particularly in your jurisdiction?
Your mic's off, Chief Leckie.
Thank you for the question, Mr. Chair. It is one of the frustrations for police officers that's been expressed in my time with the BC Association of Chiefs of Police and many of the colleagues that we work with, that it is quite often that charges that are proposed, such as failing to appear or many breaches, are either dealt away or charges are stayed. It's very frustrating because those are the very charges that are used to support holding and detaining a client in custody. So it becomes that much more difficult to be able to proceed if you can't, some of the very grounds that we would use when all the other tools have been reduced and or taken away. Again, that's just another tool that's been made less effective, which means that offenders will not have that on their criminal records when judges use or JPs use that for consideration in bail. So it exacerbates the problem of what we would consider the repeat offenders being released and rearrested.
Thank you, Chair.
Now, Mr. Chief Davis, in your testimony, you told us what it's like for police officers, people on the front line, and how dangerous that work can be and how demoralizing it can be. Yet you were quoted as saying, and I think it was in one of the local newspapers, it's not the judge's fault. They're simply applying the Gladue rules. But now we refer to the McKenzie case. This is the person who is now accused of murdering Pershala. The judge said, I'm confident that the public would conclude that the current strict plan of house arrest supervised by the accused's mother with independent monitoring and counseling is a reasonable restraint on the accused's liberty until trial. Now, clearly, in retrospect, that was a bad decision. But was the problem with the Gladue principles or with the way the judge applied those principles?
Respectfully, Chief Montour knows a lot more details on this, so I'm going to pass this over to him first.
Fair enough. So let's go to Chief Montour then. Thank you.
Thank you, sir. It's kind of both. Like Justice Arell, I've sat before him in his court before. He's a very competent judge. And as far as the Gladue factors, I know that the Supreme Court has made this case law for sentencing as well as bail for, it's quoted as aboriginal offenders in the code. But I'll refer back to my question, my opening statement. If Randall McKenzie was not an Indigenous male, would he have been released from custody? I think not, based on his criminal history. He had a robbery with a firearm conviction where he assaulted the owner of a restaurant in Hagersville, whom I know as well as other firearms offenses. He assaulted a police officer in Hamilton, and he committed other crimes involving a firearm. And again, I say race should not factor in to repeat serious offenses such as that and those offenders who are committing those crimes.
Okay, thank you.